Welcome to Metric Hub. Today I'm going to do a revision on labor relations N6. It will be a full paper revision. Right. So I'm going straight to question 1 on section A. Right. Section A, you're supposed to write everything. It's compulsory. You're supposed to answer all questions. You're supposed to answer all questions. Right. Let's go to 1.1. Choose one term from the list below for each of the following descriptions and write it next to the question number. Right. So 1.11. So here we are going to choose the correct answer from the list above. Right. So let's go to 1.1. A strike which does not carry union approval. A strike which does not carry union approval. We call it wildcat. Wildcat. It just occurred just without notice. It occurred without a notice, right? So we call it a wildcat. A wildcat. A wildcat. A wildcat. Right. So let's go to 1.12. The social and economic doctrine that call for public rather than private ownership or control over property and natural resources. We call it socialism. Socialism. Right. Socialism. Socialism. Right. So let's go to 1.13, also known as summary termination. Summary termination. Right. The answer is a downsizing. 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 So the main reason why companies downsize is because of insolvency or inability to pay. Inability to pay, right? Maybe due to what? To production loss. Right. Let's go to 1.14. Broken rule. Broken rule. A broken rule, we call it a misconduct. A misconduct. A misconduct. A broken rule is a misconduct. Right. Let's go to 1.15. To promote the interest of workers, we call it, it is a workplace forum. Workplace forum. It is created to promote the interest of workers. Workplace forum. Workplace forum. We call it WPF. Right. 1.16, disciplinary hearing. Disciplinary hearing. It's a sanction. It's a sanction. It's a sanction. Right. Let's go to 1.17. The temporary closing of the plant or department by the employer. This is what you call lockout. Lockout, which is the strike on the side of the employer. When the employer strikes, we call it what? A lockout. A lockout. Right. Let's go to 1.18. It sometimes takes place before the actual bargaining. That's what you call attitudinal structure. Attitudinal structure or attitudinal bargaining. It is not a type of bargain, rather it is a structure put in place to facilitate collective bargaining. Attitudinal. So it is there to change the attitudes of parties who are in conflict. It takes place before the actual bargaining. Attitudinal, 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 whereby it's all about coming from the word attitude, whereby it is there to change the attitudes of parties who are in conflict, right, before the actual bargaining. Remember, during a conflict or during a dispute, there will be the environment becomes hostile, right? So it is there to change the hostile environment into a friendly environment that facilitates bargaining, right? So let's go to 1.19. Disagreement or opposition between individuals or departments, we call it a conflict. Conflict is a disagreement. That's what you call a conflict. When two parties or departments are not agreeing, are disagreeing, we call it a conflict, right? So 1.110, minor transgression, we call it mitigation. A mitigation is a minor transgression. Mitigation. Right. So let's move on to question 1.2. Answer true or false. True or false. Right. 1.21. 1.21. Picketing may never take place in the premises of the business unless the employer grants permission. That's true. That's true. It only takes place in the premises of the employer if he has given the permission. Right. 1.22. The CCMA can credit business with money in order to pay their employees. That's false. CCMA is a commission of conciliation, mediation, and arbitration. Its duty is to conciliate, to mediate, and to arbitrate on parties that are in dispute. They don't deal with borrowing money to a business, right? 1.23. The state represents the workers in a strike action. The strike, so the state represents the workers in a strike action. That's false. That's false. The state is the employer. The state is the employer, right? Let's move on to 1.24. Centralized bargaining occurs at a central point. That's true. That's true. It occurs at a central point. Right. Right. And decentralized bargaining takes place at a workshop or a workflow. Right. Right. Or shop floor level. Okay. At a shop floor level. Right. 1.25. A recognition strike is to force an employer or industry to recognize the particular trade union as an agent for the company workers. That's true. That's true. Right. When an employer refuses to recognize the trade union or refuses to work with the trade union, the workers may conduct what we call a recognition strike. They may go on to a recognition strike just to force the employer to recognize the trade union. All right. Let's go to 1.626. The labor court may order the payment of just and reasonable compensation for analysis attributable to strike. Right. That's false. the labor court may not order. The labor court may not order payment. That's false, right? Employees who are involved in a strike, they are not gonna get uh, uh, salaries. They only get food and accommodation, right? Compensation. At one point, sorry, this is true. This is true, right? They may order the payment. Yes, that's true, but not a full salary, right? Let's go to 1.27. A dispute of right is more dynamic than a dispute of interest. A dispute of right is more dynamic than a dispute of interest. That's false. That's false. Right. Let's go to 1.28. 1.28. Rights are ensured by customary practice. That's false. That's false. They are not ensured by customary practices, but by common law. 1.29. Expected strike is triggered by an incident on the shop floor. That's true. Expected strike will be triggered by an incident on the shop floor. Right. Let's go to 1.210. A product boycott is aimed at consumers. That's true. Right. Product boycott is when workers persuade the customers not to buy the product. Not to buy the product, right? In order to force the employer to bargain. Right? It is conducted by the employers of the organization, whereby they will persuade the customers not to buy the product, right? Just to put pressure on the what? On the employer. Let's move on to question 2. Question 2. 2.1. 2.1. Right. List one substantive agreement from the article that the striking parties wants on or demand, right? So here we're going to talk about, I'm just going to list substantive issues that maybe you might come across the question. List substantive issues, right? So under substantive issues, we have 1, wages and salaries. So these are what you call bread and butter issues. Wages and salaries. You have working conditions. Leave days. And benefits, which are also incentives. Right. So let's go to 2.2. 2.2. If the parties fail to find each other and reach an agreement, then they will have to issue a strike notice. If the parties fail to find each other, and reach an agreement, then we will have to issue a strike notice. Indicate what other two routes can be followed to solve the dispute beside embarking on a strike by the security guards, right, by any company or workers. So the other route, it will be arbitration, arbitration, and adjudication, adjudication. Right. Arbitration is whereby an arbitrator is called to make a decision, to give a final decision to the dispute. So the decision of the arbitrator cannot be what? Appealed. Cannot be appealed at a high court or a labor court appeal, labor appeal court. You cannot appeal the decision of an arbitrator. And then adjudication is whereby you can go through the court route, whereby they go to the labor court. Right. Let's go to question 2.3. 2.3. 2.3. Right. Define the term strike. Strike. Right. It is the failure to work or a refusal to continue working or a failure to resume working. That's strike. Or it can be failure to comply with the terms and conditions of the contract of employment. Right. So failure is the refusal to work or a failure to continue working or it may be failure to resume work and lastly failure or a refusal to comply with the terms and conditions of employment. Right. So that's what we call strike. Refusal to work, failure to continue working, failure to resume work, and failure to comply with the terms and conditions of Employment Act. Right. So let's go to 2.4. 2.4. List the two purposes of a picket. List two purposes of a picket. Right. Picket, the main two purposes of a picket is to inform the public. To inform the public. To inform the public. Right. And other union that there is labor and other unions that there is a labor, there is a labor dispute. At the premises or with the employer, just to inform the public with the employer, to inform the public that things are not fine with the employer. And also to block the facility so that the plant will not operate normally or easily. To block the workout or a facility so that the company will not perform or operate easily, right, during a dispute. Right. So these are the purposes of a picket, right? To inform the public that there's a dispute with the company has a dispute or employees have a dispute with the employer, and also to block the facility so that the company will not operate smoothly during a dispute. So let's move on to question 2.5. Question 2.5. State and explain the conflict handling method that can be used to prevent a deadlock and satisfy both parties in the scenario given. We are going to state the conflict handling methods. Conflict handling methods, right? That satisfy both parties, right? Right. Remember, there are different conflict handling methods that you can talk about, right? So I'm just going to list the conflict handling methods. 2.5, right? 1, we have what you call so the answer here is collaborating. Collaborating. Right. So this one, both parties are satisfied with the agreement, right? They are satisfied, right? It is a win-win situation. It is a win-win situation. Both parties win. Both parties, they win. This is a win-win situation whereby each party will win, right? Win-win situation, right? And also, I find that it is known as problem solving. It is also known as problem solving, whereby both parties collaborate so that they can solve a problem. They can solve a problem, right? Right. So the problem is solved in such a way that everyone will be satisfied with the outcome. The problem is solved in such a way that all the parties will be satisfied with the outcome, right? So also you have what you call other methods like compromising. We also have what you call subordination. We also have what you call competing, right? etc. That there are almost 5 methods of what? Of conflict handling. Conflict handling, right? Let's move on to question 1.6, sorry, 2.6. List 5 rows of the good mediator, rows of a good mediator, rows of a good mediator. 2.6, a good mediator. All right, rows. That it includes, right, a good mediator facilitates decisions, sorry, discussions, facilitates discussions, it facilitates discussions, is a neutral person, he does not take sides. It's a neutral person who assists both sides to get rid of tension, right? And also, he intervenes more actively, intervenes more actively, and also he offers advice and recommendations to parties, offers advice and recommendations to solve a problem. You can offer advice and recommendations in order to solve a problem. And also he discovers areas of compromise, areas where they can compromise in order to solve a problem. And lastly, he encourages proposals and counter proposals. Encourages proposals and counter proposals. Right. Okay, let's go to 2.7. Discuss how the input links to the convention. The input links to the convention. Right, 2.7. 2.7. Right. So you can find that when there is a conflict, the parties involved need to try to solve the problem. Right. So in order to solve a problem, various structures which are in-house, procedures, processes are put in place to solve the problem. Right. So the type of conflict will determine which convention method will be used to come to an agreement. Right. If it is in case of maybe a higher wage or collective bargaining is possible, right? Maybe they want to, there's a conflict regarding what? A higher wage. So collective bargaining is possible, right? And then this might take place at a central or decentral what? Level, right? So if the bargain was not successful, what is going to happen? The conflict can be, it can be transferred to what? To bargaining councils, etc. Right. So that's what you'll be talking about, right? Remember the question. I was saying discuss how the output links to conversions. Outputs links to conversions. Right. Let's go to 2.8. State 3 advantages of a Gauss law. Right. So we're saying advantages of conducting a Gauss law as a type of a strike. The advantages to the employees. Right. One, they do not lose wages. They do not lose wages. Right? They also, it will be very difficult for managers to take action. It is more difficult for managers to take action against them. For managers take action against employees who are on a Gauss law. And also, employees cannot be replaced by temporary workers. They cannot be replaced because there's two, they are at work, they are at work by temporary workers. They cannot be replaced because they are at work. They are at work, right? So let's go to question 3. Question 3, right? So I'm not gonna read the paragraph or the passage. I'm going straight to the question, right? When negotiating for increase in wages, the parties will have to take the external environment factors into account. List 5 external environment, right? External environments includes economic. In fact, you can use the abbreviation so that you remember acronym for external environment. For external environment, right, which is pestle, pestle. So pestle stands for P for political. E for economical. S for social. T for technology. L for legal. And G for government. Right, pestle. Yes, so these are the economic factors. These are the economic factors. So let's go to question 3.2. List the 4 aims of dispute resolution. Aims of dispute resolution. Aims of dispute resolution. 1, which is 3.2. 3.2. Right. Aims of dispute of a dispute resolution. Right. 1, to avoid the escalation. To avoid the escalation. To avoid the escalation of conflict. Right. That might result to dispute. That might result to a dispute. 2, they want to resolve issues. To resolve issues. To resolve issues at the earliest possible. At the earliest possible. And also to collect information about the issue and to explore different options for handling it. To collect information about a dispute and to explore different options for handling it. Right. And lastly, to arrive at a solution. To arrive at a solution which both parties will accept. Which both parties will accept. So these are the aims of a dispute resolution: to avoid escalation of conflicts that may result to a dispute, to resolve issues at the earliest possible, right, and to collect information about a dispute and explore different options for handling it, and also to arrive at a solution which both parties will accept. So let's move on to question 3.3. Question 3.3. Discuss what is meant by mediation. what is meant by mediation, right? What is meant by mediation? Right. So mediation, it is when a third party is called to conciliate with parties who are in conflict. Right. When a third party, it's a third party intervention whereby a mediator will conciliate with parties who are in conflict. So normally it is a process where an independent third party is called in to assist the parties to reach an agreement. In short, it is a process whereby an independent third party is called in to assist the parties to reach an agreement. To reach an agreement. Like that's what we call mediation. Mediation, when an independent third party is called in to assist parties to reach an agreement. That's what we call mediation. So the person does conciliation. He conciliate with the with with the parties who are in conflict. Right. So the mediator makes suggestions. He makes he facilitates communication and encourage settlement. Right. So let's go to 3.4. 3.4. Is a salary a dispute of right or a dispute of interest? It is a dispute of interest. It is a dispute of interest. Right. A dispute of interest is something that you are not entitled to, but you want to be entitled to. Right. 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 For example, increase, you want an increase in salary. It's not a dispute of right, but it is what you want to be entitled to. Right. So it will be dispute of right, of interest. Right. Let's move on to question 3.5. 3.5. Question 3.5. Question 3.5. Right. State 5 structures that can be established to ensure effective communication at the workplace. 5 structures includes to facilitate or to ensure effective communication at the workplace. We find that we have workplace forums, also have what we call briefing groups, briefing groups, another structure, shop stewards, shop stewards, shop steward committees. Right. We also have health and safety, committees, health and safety committees. Right. And other consultative committees. Other consultative committees. Right. Other consultative committees. Right. Let's go to 3.7. 3.7. 3.7. Distinguish between collective grievance and individual grievance. Right. So we're going to distinguish between collective and individual. Right. So let's start with the collective grievance. A collective grievance. Right. Collective grievance, it relates to common working conditions and wages. It relates to wages and salaries.
Oh, I don't know what I tell you. What's going? It's my phone.
Wages and salaries. Right. So it is channeled through the trade union. It is channeled through the trade union. It is channeled through the trade unions. Right. Right. So it occurs when all employees are not happy. When all employees are not happy, about something, when all employees are not happy about something. Right. So a group of people have a complaint, for example, maybe about the e.g. maybe happy about the working conditions. So what will happen? A trade union representative will bring it to management. A trade union representative will bring it to management. Right. Right. So that's a dispute, collective grievance. Collective grievance. That's collective grievance. Right. Right. Let's discuss individual grievance. So we're saying collective grievance is normally relates to common problem whereby employees are not happy about something. For example, they might not be happy about the working conditions. So what will they do? They will then form a group and organize what we call a trade union. Right. So the trade union representative will then go and negotiate with the management on behalf of all employees. Right. We call it collective grievance. Right. So let's talk about collective grievance, individual grievance, and individual grievance. Right. So this one has nothing to do with the trade union. Right. It can only be channeled through, this one is channeled through through the grievance procedure, right? And also, the discussion, it is discussed during personal interviews. It is discussed through personal interviews. Right. So here it is when one person, when an individual has a complaint, if the individual has a complaint, maybe it might be regarding maybe working conditions or aspects of work. So what he does, he approaches the what? Management. He approaches the management. He approaches the management by himself. Right. So the only difference is, on collective grievance, it's a group of employees, all employees are having a complaint. And then on individual grievance, it is when an individual has a problem, right? And then on collective grievance, you can find that the issue is handled through the trade union, who represent what? The workers. While it's in individual grievance, you can find that the issue is handled through personal interviews or personal discussions. Right. Okay. So let's move on to question Question 3.8. Define conflict. Right. Conflict is a state of disagreement between two parties or groups. Conflict. Conflict is a state of disagreement between two parties. Yes. Right. That's what you call a conflict. A conflict. Right. So let's go to question 4.1. 4.1. 4.1. right? List the 3 circumstances that lead to retrenchment. Circumstances that leads to retrenchment. Right. So retrenchment is when the management is downsizing its employees. Right. So there are so many circumstances that causes what? Retrenchment. One of them is increased competition. Increased competition. Two, it might be economic consideration, whereby the company can no longer able to pay salaries. Consideration, or maybe the sales has decreased, or it might be due to relocation. Relocation, maybe due to relocation of a plant of an enterprise. Relocation of an enterprise. Right. Or it might be due to technological development. Technological development, due to technological development. Maybe they want to introduce advanced machines, right? Or it may be due to takeover and measures. Maybe due to takeover, right? And measures. Sometimes a company that is take over, the company might not need maybe they might bring their own, or they will bring their own workers. So organization has no choice there. It has to what? Retrench. Right. So let's go to 4.2. 4.2. State 5 factors which to be considered with trade union for retrenchment to be considered as fair. Right. For the retrenchment to be fair, right? There should be fair selection. Fair selection. Right. For retrenchment. Two, the union must receive proper notice. They must receive proper notice of retrenchment. 3, the employer must negotiate the need to retrench with union. Must negotiate the needs to retrench with the union. 4, there should be alternatives. Alternatives for retrenchment. Alternatives for retrenchment must be discussed. Must be discussed. Right? And also, there should be basis for retrenchment. They're supposed to be discussed. Basis for retrenchment. This is for retrenchment must be discussed. Right. Lastly, there are 5. Lastly, the enterprise must undertake to re-employ retrenchment workers in their position should the vacant is available again. All right. So let's go to 4.2, 4.3, 4.3, 4.3, 4.3. It must be noted that following an extensive consultation process, it must be noticed that following an extensive consultation process, discuss the role that downward and upward communication plays to ensure good labor relationships in the organization. Downwards and upwards plays to ensure good communication in the workplace, right? So here we will only discuss the importance of what? Of communication. Importance of communication. Right. 1. It ensures a healthy labor relations. Good communication ensures a healthy labor relationship. Ensures a healthy labor relationship. And also, you can find that labor relations and communication process are interwoven. They will not do without each other. Labor relations and communication are interwoven. They cannot do without each other. They are interwoven. Right. Right. 3. Lack of communication. Lack of communication. Lack of communication channels will result in disputes. Right. Also results in grapevine. Right. And distortion of information. And distortion of information. Right. Right. So, good communication assists with the survivor good communication and a healthy labor relations assist with the survival of the organization. Right, they assist. And also, when there is a good labor relations and good communication within an organization, there is a possibility of reduction of conflict and social unrest. Reduction of conflict and labor unrest. Labor unrest, we're talking about strikes, right? Right. So let's move on to question 4.4, right? 4.4, right? State 5 alternatives to replacement. Alternatives to replacement. So instead of retrenching, an organization might freeze freezing of post, they might freeze post, right? Or they might offer what you call voluntary retrenchment. Voluntary retrenchment. Might offer voluntary retrenchment. Or they might reduce the number of shifts. The number of shifts. They might also stop subcontractors. Subcontracts. They might also request older employees to retire early. Request older workers to go for an early retirement, to take early retirement. Right. Right. And lastly, they might temporarily close the plant. Temporary closure of the organization. Right. Or we can close certain sections. So these are what we call alternatives for retrenchment. Instead of retrenching, my organization might freeze post or offer voluntary retrenchment. Those ones who want to go, we can by maybe offering attractive packages, right? So for example, severance pay, right? And then they can reduce the number of shifts or stop subcontractors, or they can request older workers to take early retirement, or they might temporarily close certain sections, right, of production. So let's move on to question 4.5. Explain what is meant by the term conciliation. Conciliation What is conciliation? To reconcile. To reconcile is to bring parties closer together, right? So that they can continue the relationship that they were having before the conflict has existed, right? And also, it is a voluntary process, right? So, conciliation seeks to improve the problem solving skills of opposing what groups, and then you can find that it is established an integrative structure of interpersonal relationships, right? So conciliation entails that the continuation of negotiations between two parties in which the conciliator assists the facilitation of what? Of the communication. And that's what we call conciliation. When you are bringing two parties together so that they can continue their relationship that existed before the existence of the conflict, right? And also it seeks to improve the problem-solving skills of opposing groups, right? It also establishes an integrative structure of interpersonal relationships, right? And it means continuation of what? Of negotiation between the two parties in which the conciliator will assist with the facilitation, right? So that's what you call conciliation. Conciliation. Bringing both parties together so that they can negotiate, so that they can continue their relationship while still solving the problem. Right. So let's move on to the question 5. Question 5. Question 5. Question 5. Question 5. Right. It's 5.1. 5.1. State 5 reasons why it is important to solve conflict in the workplace. Why is it important to solve conflict in the workplace? There are so many reasons, right? 5.1. Reasons for solving conflicts, right? Right. So 1, right, to avoid a hostile environment. To avoid a hostile environment. To avoid a hostile environment. That's why it is very important to resolve a conflict. A hostile environment is not a productive environment whereby opposition people who are on the opposite, they see each other as enemies, not as opponents, right? And also to ensure productivity, we need to resolve conflict. To ensure productivity. For us to ensure productivity, we need to make sure that whenever there's a conflict, we resolve it. And also to avoid losing business. To avoid losing business. When a conflict is not resolved, it becomes a dispute. Right? That might result to industrial action. Right? For example, industrial action like industrial actions like picketing and go slows, right? Right. Avoid losing business, right? And also to keep communication channels open. To keep communication channels open. keep communication channels open. We need to resolve conflict, right? And also to ensure high morale, we need to resolve conflict. And also to help to raise and solve problems. So it helps when we resolve problems, it helps to resolve problems. Resolve problems. And lastly, to avoid grapevine and rumors. To avoid grapevine and rumors. Right. Right. Let's go to 5.2. 5.2. Define the term dispute. Define the term dispute. So a dispute is defined as a continuous disagreement between an employer and the employees with regard to matters of concern, right? Right, or work-related factors affecting their relationship, right? So a continuous is a continuous disagreement between the employer and employees, right? With regard to matters to common interest, regards to common interest, right? Or work related factor. Affecting their relationship. Right. So that's what you call a dispute. A dispute. Right, let's move on to 5.3. List and explain 4 conflict indicators. So I'm going to explain and give an example of conflict indicators. 5.3 conflict indicators. Right. Those are what to call flags that shows that there is a conflict within an organization. Right. 1, alienation. That we'll be talking about poor housekeeping, poor timekeeping, it may be increased absenteeism, might be high labor turnover, right? And then 2, production attack, which is also an indicator of conflict. Production attacks. Right. Which includes go slow, stay away, strikes, right? Anything that attacks production, right? Attacks production, that's what we call production attack. 3, we have what we call deterioration of work relationship. Deterioration of work relations. Deterioration of work relations. E.g., increased disciplinary, interviews, increased grievances when there is a lot of grievances. It means that there's a conflict. Right. So let's go to 5.4. Explain 5 roles of the arbitrator. All right. Roles of an arbitrator. Roles of an arbitrator. Right. Which is question 5.4. Right. Roles of an arbitrator. Right. An arbitrator actively intervenes in the conflict, in the dispute. Actively intervenes in a dispute. Right. He also takes over the role of a decision maker. The role of a decision maker. Takes up the role of decision maker. Later, also listens and investigate. Listens and investigate. The demands and counter demands. Demands and counter demands. Right? An arbitrator also makes a decision. Provide solution. And takes a decision and takes a decision and terminates the dispute. Right. He also decides on the final settlement. Decides on the final settlement, which is the final decision. Right. Right. His decision is binding. His decision is binding. Right. Let's go to 5.5. State 5 functions of collective bargaining. We are going to list the functions of collective bargaining. 5.5. Functions of collective bargaining. Right. So 1, to establish a uniform framework for disciplinary action. To establish workplace rules. To establish workplace rules. To determine compensation. To standardize compensation. We want to standardize compensation. Put a standard on compensation. To determine priorities that will need attention. And lastly, ongoing reconsideration of bargaining arrangements. Right. So these are the functions of collective bargaining. To establish workplace rules, we need to bargain collectively. To determine compensation, to standardize compensation, determine priorities, ongoing reconciliation of bargaining arrangements. Right. So let's go to question 5. Question 5. Question 6, right? And question 6. Right. Explain 3 reasons why a business must have a disciplinary code. Reason a business to have A dictionary code. Question 6. Right. So the reason why a business should have a dictionary code is one. Right. Right. To establish a uniform framework for disciplinary action. Establish a uniform framework for disciplinary action. Two, to address unacceptable to address unacceptable behavior. Two, three, to document the process. To document the process. Four, to secure consistency. Lastly, to have evidence. To have evidence if necessary in the future. Right. Okay, let's move on to question 6.2. State 4 reasons for an appeal hearing. State 4 reasons for an appeal hearing. Reason for an appeal hearing includes one, procedural unfairness, when the procedure was not fair, or might be substantive unfairness, right? Might be sanctions for transgressions, And lastly, other errors. For example, the chairperson was not impartial, or new facts have come to light. Right. Yes. So let's go to 6.3. 6.3. Right. Define collective bargaining. Collective bargaining. Right. We're going to define collective bargaining, 8 marks. Define collective bargaining, 8 marks. Six point three. Right. Collective bargaining is a voluntary process. Collective bargaining is a voluntary process. Right. It is initiated by a trade union. It is initiated by a trade union. It is dynamic in nature. Right? And also it involves a two-way process. Involves a two-way process. And also it is a method of reconciliation. It is a method of reconciliation or reconciliating. Right. And also it is a tool. It is a tool to improve wages and working conditions. Yes. That's collective bargaining is voluntary. It is initiated by the trade union. It is dynamic in nature. It involves a two-way process, right, whereby there is a pressure and counter pressure. It is a method of reconciling, and also it is a tool to improve wages and working conditions. So let's go to question 6.4. 6.4. Distinguish between centralized and decentralized bargaining. Centralized and decentralized bargaining. We are going to give a difference between centralized and decentralized bargaining. Centralized and decentralized bargaining. So if you are told to distinguish, just tabulate. Right. This one is decentralized. Bargaining. Right. So centralized bargaining, right, takes place at a bargaining council. takes place at a bargaining council. Takes place at a bargaining council. Whilst decentralized takes place at a shop floor level. At a shop floor level. Centralized bargaining must be recorded. Sorry, before talking about recorded, it is a formal bargaining. It is a formal bargaining. And decentralized is an informal bargaining. It is an informal bargaining. And also, centralized bargaining, recognition must take place. Recognition must take place. Recognition must take place. For it to take place, recognition agreement must take place. Whilst decentralized, there is no recognition agreement required. Recognition agreement is not required. It is not required. Yes. And also you can find that agreements, right, in the centralized bargaining binds all employees in that industry. Agreements binds all employees in that industry. But decentralized bargaining can find that decision agreements binds employees in that organization. Agreements binds employees in that organization only. It binds employees in that organization. Let's move on to question 6.5. Name and explain 4 types of strike. Right. Types of strike. I'm going to write it here. Types of strikes. Right. So I'm going to list the types of strike and then explain them. Right, we have what we call economic strike. We have what we call wildcat. There's also another what we call recognition. Strike, rotating, rotating, also I have sit-in. There's also another strike which is sit-in, strike, strategic, strike,